I want to bring in our guest right now, joining us, criminal defense attorney, former prosecutor Bob Bianchi. Bob, great to see you. Thank you so much for joining me on the program. I want to get your thoughts quickly about what we're hearing here. I think she was pretty clear on the science. I was trying to find it. You know, we're not science guys generally, although many times at trial you have to become experts in things very quickly. But I thought if a juror's listening to this, you can clearly understand 0.093 times by 1,000 to get the blood alcohol level. And based on the variation, it could be between 0.078 and 0.092. One of those, at 908 at least, is legal. One of them isn't. Your quick thoughts.
Well, I was listening to this, and after, I guess you do this long enough, Michael, you get to a point where I'm like wondering how many defendants that I put in jail for the rest of their lives are now wondering, oh, they changed the science again, and now it's to the benefit of the defendants. I just don't understand in today's day and age how things are being updated like this and they change. So I guess my initial reaction to it was that in the beginning of my career, I believed everything was scientific and it was absolute. And now I see the science bends as time goes on. Nevertheless, the importance is going to be, as you indicated earlier, to the extrapolation, the metabolic burn off, what the blood alcohol content was at the time that she left that area. And it's interesting from a strategic point of view. What are they going for here, manslaughter or murder?
Well, they have the two charges, right? So this particular testimony would really, I think, on some level, create problems for the second-degree murder. But I think they need it, of course, for the vehicular homicide and the felony vehicular homicide. So they have to, if you have both charges, you got to go at it in both ways, correct?
Yeah, absolutely. But I mean, just personally myself, strategically, I never want to argue a malice standard or in New Jersey it'd be an intentional or knowing act and a reckless act. I don't like to be in two worlds and making an alternative argument to the jury, which goes like this. It was malice, but if it wasn't, it was reckless, which is a defense lawyer is going to come back and say they can't even tell you what the theory of their case is. So I understand why they're doing it. I just don't want to be in that particular space unless the law requires it. But I don't think that's a lesser included offense of second-degree murder, at least in my mind. So the state, I don't think the state can have its cake and eat it too here. I think it's confusing to the jury. What's your theory of the case?
No, I agree with you 100%, and that was going to be my question. It is not a lesser included. So what you're saying is, as a prosecutor, if you took a case like this, you'd really be going all or nothing? Because again, what it sounds like they're doing here is hedging their bets on some level, because I think it's fair to say, and I think you and I have talked about this, we're not so sure about that second-degree murder charge based on the facts as we know them from the first trial and what we've heard so far. And, you know, hedging your bets may not, under all circumstances, be the worst thing.
You know, it kind of fits to me. I mean, listening to this case as an outsider, I don't have the file, obviously. You know, Michael, we're armchair quarterbacks when we do these things here in the media. But when she's saying, did I hit him? Did I hit him? And the frantic nature of it and her going there when no one else could see it, this could be consistent with somebody who at 9 o'clock has a blood alcohol level potentially of 0.092. 0.08 is the legal standard, just so your audience understands. That would mean at the time that this incident happened, her blood alcohol level was so high. Is it possible, the jury says, that she actually hit him and didn't maybe even know it, kind of suspected it, went back to the scene and said, this is probably where it is, and maybe this was just a horrible accident? I mean, it definitely fits to me better in the facts than the malice murder does so far.
No, I agree 100%. I think if you ask me right now, and you force me to come up with a theory of the case, that would be my theory, because all of her actions don't really fit under any other theory. Why would someone go right to, when they're talking about something happened to someone who didn't come home, even talk about hitting them if there wasn't something knocking at the back of their head? Either they knew they did it or something knocking in the back of their head that they hit something that night, but they were a little drunk, can't quite remember. She's all over the place in terms of where she left him. First she says she left him at the bar, then left him at the house and saw him go in. She's telling that story as well. So that's the one that I would align with, and I wonder why the state decided not to go in that direction.
Yeah, it's a little confounding, and I agree with you completely. I mean, sometimes, you know, you get slaughtered because you're in too many different spaces. As a prosecutor, you have to argue with the most likely analysis of the evidence is. And I don't like, and I think that there's a theory out there, and I'll tell you what it is, and I don't agree with it at all. It's like, let's charge like a super high offense and have the jury compromise to something less. The problem here is, though, in my mind, a jury could sit there, and if you lose credibility in the theory of a case as a prosecutor, you could get one juror, at least, or maybe multiple jurors that say, you know what, if I can't trust the prosecution's analysis of the case and so many of these cops did the wrong thing here, and one actually got fired. It's so confusing to me. I'm not going to say guilty. So I think they maybe thought that it was a smart thing to do. But if it's a manslaughter case, you have an ethical obligation. Only prosecute a manslaughter case. And that's what I'd be saying as a defense lawyer. They don't want you to rely on it. They want murder because they overcharge this case. They don't know the theory of the case. And they threw manslaughter in there as a token throwaway, but don't fall for it. You're giving a defense an argument here.
Yeah, and it's tough to make that argument when you're basically saying there's a cover-up and she did nothing wrong at all, right? So you might not go in that direction. Quickly, before we go to break here, I want to get your thoughts on the entirety of Jen McCabe's testimony. She finished up today, her cross-examination, some redirect, and then just a little bit of recross. I want to play a little sound. This one goes to a big part of what I think the defense was trying to establish. This involves collusion, this idea that she was talking to a lot of people in ways that, I don't know, seemed a little bit weird. And then I got a question for you. Let's take a listen.
You certainly did not expect when you were writing those texts that the defense, Ms. Karen Reed's representatives, would ever get a hold of those texts. That was not in your mind, correct?
Would never have been in my mind, no.
That is a textbook example, what we've just seen, of witnesses colluding with one another about a subject matter that's under investigation, correct?
Bob, a lot of people online believe that Jen McCabe won, right? I mean, people like to put things in terms of who won this cross, who won that. They believe Jen McCabe won. They were really impressed by her new demeanor, by her new look even, feeling like she held her own, that this was all innocuous, nothing going on here. But in my eyes, and again, I look through it through a defense's, lens at the end of the day, but I feel like there was enough raised in terms of stuff like she called John O'Keefe a number of times and they were butt dials. She's talking about, getting into these groups and talking to people in ways and times that seem a bit odd. The suggestion that this little chat group and some of the things they said to each other suggest they might have been trying to hide something or get together their story. I think all of those things landed to the point where a reasonable juror could look at it and say, you know what, there's something fishy here, and while I believe a lot of what she's saying, I can't go all the way.
Yeah, and of course the Google search and when the Google search happened, which is another huge issue in the case. I agree with you, Michael. I at a minimum with me, having done this for a long time, they're covering something up. And I've been around long enough to know it could be something, maybe an extramarital relationship or an affair. It doesn't, or gamble. I've seen so many things where people are perceived to be lying about the substance of the incident itself, when really it was they were trying to cover something else up. And we just don't know what it is. But all the things that you just sat there right now, look, the defense doesn't have to prove anything. It's the prosecution's witness. They put her on. They're vouching for her. And the very items that you just brought up there, and including this weirdness of the search, how long to die in cold, is just something that doesn't square with somebody who has nothing to do, with this particular incident or potentially as a motive. And again, all you need is one juror to say, They relied on her testimony. They needed her. They had to have her. And I'm just not satisfied she convinced me to convict.
Yeah, and Bob, what hit me too is she's out in front of the house. She's looking for somebody to perform CPR. She knows she's got the first responder in the house. She's close to her sister, talks to her all the time. Doesn't call them and say, hey, you guys better get out there. John's out here, you know what I mean? Never does any of that. It all, it's just, again, doesn't smell right in some little bit of level. All right, Bob, stand by.